Okay, we're going to talk about jurisdiction in support cases, and very briefly, again, I'm going to do these in little short segments. We're going to talk about the concept of long-arm jurisdiction. If you've had civil procedure, you may remember it. But what establishes minimum contacts for personal jurisdiction in a family law case is a little bit different than in other cases. So if we have state-to-state conflicts or country-to-state conflicts with divorces or support mostly, because divorce, as you remember, is based on domicile. There's a case in your book that talks about a Haitian divorce decree, and someone who lives in New York gets separated. Their wife and children move to California, and she decides to get a Haitian divorce and get full faith and credit in California and get the California courts to bear on support. And the court initially said that the husband, who still lived in New York, had minimum contacts with California to give California personal jurisdiction. So remember minimum contacts. In order for a forum state to have jurisdiction over someone's personal jurisdiction, that person must have minimum contacts with the forum state. And typically in a civil case, if you do business in that state, so if you're Walmart and you do business in all 50 states, or if you have an online business, you do business in all 50 states, or if you work in a state personally, live in a state, you have jurisdiction. That state has jurisdiction over you. But in this particular case, husband had not gone to California. Husband just had kids in California. And so husband transacted business in California when the kids left California to visit him. His children live there. He was the non-custodial parent. And the courts are trying to use this civil minimum contact standard, which really applies much more clearly to true civil cases like car wrecks and contract disputes and things like that, than it does over family law cases. But the courts initially said that that's minimum contacts. It is not. And so the case in your book talks about the fact that just that you have kids in the forum state is not enough to render that forum state to have jurisdiction over you. This is different from a divorce decree. And so the divorce is between two adults, two people who are married. One can get a divorce in a state that they move to because you're entitled to be unburdened by a marriage if you want to be. Remember that all 50 states now allow no-fault divorce. So literally, the reason is I don't want to be married anymore. And I can do that even if I can't find my husband. I can do that even if I have no idea where he is. I have the right to be not married any longer. So I can move to a state and they can have jurisdiction over my divorce, because if I live there, I personally have the right to be not married anymore. It's not the same when it comes to support. So we can't have jurisdiction in a state where someone doesn't have minimum contacts. And if I move to a state where I take my children with me, then my ex may not have minimum contacts with that state sufficient to allow for that action in child support or a custody action to be brought. So the court talked about reasonableness, and essentially she moved all the way across the country. And now if California has jurisdiction, we would make someone who's never availed themselves of a California court or a business or home come fully across the country in order to defend themselves in this litigation. So the court said jurisdictionally, that's not going to happen. Okay, that's it for that case. That case was Kulko versus Superior Court on 768.